Okay. Hang on one moment, please. So, Mr. Lau, you're here, and is Mr. Woodby, or is he here as well? He's not here. Okay. Okay, we're going to call all the Gonzalez matters right now. Is that all right? Are you guys ready? I have to talk to you guys about something on the record. Yeah, go ahead.
Morning, Ken Law for the plaintiff KFG properties on the civil number 2121. We're ready for trial.
So was the court.
First, can we pre-call to see whether the defendant is here?
Hang on, Mr. Lau. Okay, good morning, counsel. The court was prepared to hold trial today on the possession issues on both of your cases. Yesterday afternoon, I was faxed a letter from Ms. Gonzalez, and I'm going to read the letter in the file. Dear Honorable Judge, I am currently experiencing an extreme emergency that prohibits me from attending court on July 30th, 2021. I got injured on Wednesday evening, and now I am in pain, dizzy, and my balance is off. I can barely get out of bed and walk, and writing this letter is very challenging. I have a video appointment scheduled with my doctor for 9:20 a.m. today so he can evaluate my condition and determine how long it will take for me to recover. His letter will be faxed shortly thereafter. Please continue all of my cases. On a side note, I was ready to defend myself in court on Friday, July 30th, 2021. Thank you for your time and special attention needed in this matter. Counsel, did you guys get a copy of this letter?
Good morning, Your Honor. I did call the district court, and they said trial would be on today.
Ms. Orke, did you get a copy of this letter from Ms. When did you get a copy? And you got it directly from Ms. Gonzalez?
No, I did not. I saw it on Jeff's because I was sent an email
Okay.
in the afternoon.
Okay.
So,
4 o'clock. Okay. Before you came in, the court already stated it was prepared to go forward on the trial on the possession issues today. Except I got this letter, and then I got this letter from Straub. Did you also get the letter from Straub?
Around 4 o'clock. Yes.
Okay. Okay. So the counsel has seen the letters.
Yes,
Okay. As I said, court was prepared to have trial today on the possession issues. I appreciate that this may be a stalling, and I fully acknowledge that this may be a stalling technique. What it is. And so the court's going to continue all of the hearings and the trial in this matter. The question I had for you is, what do you want to do now? Here's a couple of options. I will continue this matter for a week. I will continue it for 2 months. I will do what you guys want to do. Mr. Lau, I'll hear from you first.
So, I'd like to note my objection to this last minute filing of the letter for continuance. She did attempt to file a motion to continue way back in July 8th of this year, and it was already denied. I mean, she has abused the court system and strung us out this length of time, Judge, especially in my case. You know, we gave a 45-day notice for her to vacate based upon a family member attempting to move back into the parents' dwelling. And there was an exception to the moratorium. And now, 6 months later, we're still at the same boat. You know, we can't even have possession. I just want to note my objections to the continuance. But if the court is inclined to grant the continuance, I want the trial to be set for next Friday.
Okay. Ms. Orke, Mr. Withy?
we totally agree with Mr. Lau. All our witnesses are here. Everyone is here, Your Honor. We're prepared. And this is waste of the court's time. We also had a discovery motion this morning.
Understood. I concur with all of you. Notwithstanding, given the letter from the doctor, the court's not prepared to issue a writ of possession today. Court will continue this matter for next week, Friday, and then we can go from there. And if we have the same situation next Friday, you can file appropriate motions or take whatever other appropriate methods or action you wish to do, okay? So this matter, all of these matters are continued till next Friday. What date is that?
You've been asked to provide discovery now for 4 months.
Okay.
Any testimony you can take on that one?
I'm sorry, go ahead with the date.
August 6th at 9:30.
Okay, so next week, August 6th at 9:30. So on your discovery motion, you guys have asked for that several times, right? Okay, she doesn't seem willing to do it. I will listen to what she has to say, but given that she's not providing the information that you want, it seems to me that the sanction for that is she's not going to be allowed to put in that kind of any evidence along those issues that you've asked in your interrogatory along those issues, because she's been ordered to produce some of that and not. I'm not making that order today, but was going to be my inclination for that hearing. I get that.
Just hoping we could get started on that discovery.
Is there any of that? It didn't strike me that any of that discovery was necessary for your folks', that was on her counterclaim, or was that on her
319 and the counterclaim.
There's 2 cases in fact.
well, is one of them on her affirmative claim for emotional distress death?
Yeah.
Okay. Again, the court was inclined, if she's been ordered to produce that stuff, to her detriment, if she doesn't produce it, her case is going to get, I didn't see where it was necessary for your defense per se. But it is necessary for her affirmative claims, and if she doesn't want to produce that information, there go her affirmative claims. Okay?
You asked for the name of the witnesses, and she wouldn't give it to us.
Right. Understood.
Following it.
And you guys, when we get to trial on that one, then you file your appropriate motions in limine. But we can consider that again. You can that's not an order. That's the court's inclination at this point, because she has been ordered to produce that information before. Okay?
One more note for the record,
Uh-huh.
Belinda. I'd like the court to also note that we had a mediation hearing scheduled for June 2nd. We spent a whole hour waiting for her presence. She never showed up for the mediation. So I'd just like the court to know that mediation was attempted, and I don't think the judge should order us to go to mediation again because she never showed up the first time.
Court will not order you guys to go to mediation again.
Is it possible to do that Friday by Zoom?
Yeah.
Well, no, if you go to trial, obviously.
The trial is physically present, right?
Yeah, but I mean, right now, she has asked for a continuance for today. Court is granting the continuance until next Friday. We'll see and let me ask again. So you only got notice of the letters by looking at the docket, not because you got copies of it. Okay. Let me also, for the record, admonish Ms. Gonzalez for the ex parte communication with the court and not providing counsel. And I will admonish her that in person for not providing you copies directly. It was not incumbent on you guys to look at the docket and find out that she had requested the continuance.
Thank you, Judge.
Thank you, Mr. Val. Thank you, Mr. Withy. Thank you, Ms. Orte. Have a good weekend.